Hi, I'm Dr. Rellis, and I want to address some frequently asked questions about waivers for unlawful presence, for crimes, and for misrepresentations or fraud in the U.S. immigration system. What is a waiver? A waiver is a legal forgiveness or pardon that allows certain individuals to overcome specific grounds of inadmissibility or deportability from the U.S., and instead enables them to enter or remain in the U.S. When is a waiver for unlawful presence needed? A waiver for unlawful presence is typically needed when somebody accrues unlawful presence in the U.S. The 3-year bar applies to individuals who accrue or collect more than 180 days, but less than 1 year of unlawful presence inside the U.S. and then depart. The 10-year bar applies to those with more than 1 year inside the U.S. in unlawful presence and then depart. Who is eligible for a waiver for unlawful presence? Individuals eligible for a waiver for unlawful presence are typically immediate relatives of U.S. citizens. The qualifying relative, being a U.S. spouse or parent, must demonstrate extreme hardship if the waiver is not granted. Can a waiver overcome criminal grounds of inadmissibility? Yes. Waivers are available for certain criminal grounds of inadmissibility. However, not all crimes are eligible for waivers, and the type of crime and other factors will determine your eligibility. Can a waiver overcome fraud or misrepresentation? Yes. Waivers are available for fraud or willful misrepresentation. Individuals who have made false statements or engaged in fraudulent activities may be eligible for a waiver depending on their circumstances. Who is eligible for a waiver for fraud or misrepresentation? Eligibility for a waiver for fraud or misrepresentation depends on factors such as the nature and extent of the misrepresentation, the relationship of the qualifying relative, and the impact of denial on the qualifying relative. What is extreme hardship in the context of waivers? Extreme hardship is a key element for many waivers. It refers to more than the usual hardship associated with separation. It involves a higher standard of harm to the qualifying relative, often encompassing emotional, financial, health, or other significant factors. How is extreme hardship demonstrated in a waiver application? Extreme hardship must be documented with evidence such as medical records, financial records, expert opinions, and other supporting documents. An experienced immigration attorney can help you compile a very persuasive case. What is the I-601 waiver and the I-601A provisional waiver? Well, the I-601 waiver is the general waiver for various grounds of inadmissibility to the U.S., while the I-601A provisional waiver is specific to unlawful presence only. That waiver allows certain applicants to apply for it, get approved, and then briefly depart the U.S., have their consular interview, and re-enter as a legal permanent resident. Due to the very complex nature of immigration law and the potential consequences of denial, which can be absolutely devastating to your family, seeking assistance from an experienced immigration attorney is highly, highly recommended. Navigating the waiver process in the U.S. immigration system involves intricate legal considerations, and professional legal guidance is crucial, number one, to assess your eligibility, and also to compile compelling evidence and increase the likelihood of a successful outcome for you. Individuals considering waivers should consult with a qualified, experienced, and honest immigration attorney to understand their specific circumstances and to explore for you the best course of action to get you approved.